Hello guys, so let's begin from Charter of 1861. Following the First War of Independence in 1857, control of East India Company territories in India passed to the British Crown because at that time the British government felt that because now there is this huge Sepoy mutiny of 1857, the administration and the kind of ruling that Britishers were doing on their own territories, that was also quite disappointing for the British government, and it was poorly administered. So British government decided that now East India Company will not be ruling India, but the British Crown, that is the British King directly, will rule the country, so that these kinds of war can be avoided. The Government of India Act 1858 authorized British Crown to take over the administration of all territories from East India Company. So the authority which was ruling India before 1857 revolt was East India Company, right? British East India Company. But after this revolt took place, the Government of India Act 1858 gave power to the British Crown, that is the British King, to directly control and administer all the territories which were occupied by the East India Company at that time. The Act also vested the power to appoint Governor General in British Crown. In 1861, Indian High Courts Act and Indian Councils Act were passed by British Parliament, which empowered Her Majesty to issue letters patent establishing high courts in 3 presidency towns. By this time, I guess everybody knows what this term 3 presidency towns refer to. Madras, Bombay and Calcutta. These 3 towns. So these were the presidency towns that were also under the control of Britishers from the time beginning, and to establish the post of Governor General and to appoint it directly by the British Crown, and the power to Her Majesty or the Queen to establish high courts and Indian councils in India. The former provided for abolition of Supreme Courts of Judicature and Sadar Divani Adalats, and constitution of High Courts of Judicature in their place in 3 presidency towns. Now, we have discussed in the previous videos so far that how the Supreme Courts were established in various different timelines in the 3 presidency towns of India at that time. So now this High Courts Act, which was passed in 1861 by the British Parliament, according to that, all those Supreme Courts in these 3 presidency towns, that was abolished, and in its place High Courts were established. So you see, Supreme Court gone, High Court came. The chartered high courts remained as highest courts in India till establishment of Federal Court of India under the Government of India Act of 1935. So at that time, which was the highest court of law, the chartered high courts for the whole of the country, it was the highest court of law, and this was till 1935 Act was passed, which gave the power to establish the Federal Court of India. By virtue of section 16 subclause A, power was reserved to Her Majesty to constitute similar high courts in other territories which were not within the local jurisdiction of any of the 3 proposed high courts of Calcutta, Bombay, Madras. So the areas or the territories which were not under the bounded area of Calcutta, Bombay or Madras, to establish similar kind of high courts in those other outside territories, also outside territories in the sense outside the jurisdiction or area of Calcutta, Bombay, Madras, whatever the territories were, that were obviously under the control of Britishers only at that time, तो उनमें भी similar high courts establish करने की पावर भी Queen के पास थी, Her Majesty मतलब Queen के पास थी, by virtue of section 16 subclause A of High Courts Act. The Indian Councils Act empowered Governor General to create local legislatures in various provinces through the exercise of this power. So it's through only. It's not though, it's through. it should be through. The Indian Councils Act impart Governor General so that he can make local legislations, mean local bodies can be made which will be framing laws so that the local situations or the problems of the people at the local level, at the district level, sub level can be resolved. So that was the power given to the Governor General as per the Indian Councils Act, which was passed in the same year along with the High Courts Act. So this is the pictures which are shown of the three high courts. Now, the charter high courts initially administered their jurisdiction only within the presidency towns. Subsequently, their jurisdiction got extended to entire presidency. The charter high courts, being established by Act of British Parliament, had power to issue prerogative writs. Writs were the normal method of commencing a local action in king's courts such as high courts. So the charter high courts, that main function was and to administer the cases or to deal with the matters that are within the presidency town in which they are established. But later on, gradually their jurisdiction got extended, means the matters with which they can deal, that got extended to the entire presidency. It was only to the town earlier, but now it got extended to the presidency. Charter high courts, which were established by the High Courts Act of British Parliament, can also issue writs at that time. So writs are nothing, just a way of filing a complaint so that the proceedings can begin in the court thereafter. The power to issue writ in nature of habeas corpus was curtailed by Section 491 of Criminal Procedure Code 1898. So this is also a writ. Habeas corpus is a term which means bring the body. Corpus means body, so it's body doesn't mean the dead body or the deceased person, but it means that any person who is held in the imprisonment term which is more than the imprisonment that should be provided to him as per the crime or wrong that he has committed. Like if I take an example, there is a person A who has committed robbery, so for that maximum he can get 7 years of punishment, minimum 3 months or so, and maximum he can get for 7 years, let's say. Now he is given 7 years of punishment, like you have to be in jail. So as soon as the crime is committed, the person is arrested, right? When investigation got complete, there was a doubt on this person A, so he got arrested and he is put in jail directly. So now the case, now also there is a trial which has to go on in the court for this person, because you have arrested him on the basis of doubt after your investigation. So now that doubt has to be completed either in a positive manner or either in a negative manner. That is, either he has to be proved guilty or he has to be proved innocent for that, right? So in that case, proceedings or trial will be held in the court, where this person A or the representatives of A will also be given a fair chance to represent themselves, to say that what their side of the situation is. So keeping that things apart, a case will be going on in the court for this person A, and we all very well know the kind of pendency of cases because of which there is a huge delay to complete the matter, to solve the matter. So for instance, if this person is in jail for 8 years continuous period because the case was going on in court, until and unless the case gets a matter resolved, the person can't come out of the court, because if he is found innocent, then only he could be set free. Otherwise he has to complete his punishment term. So he has to be in imprisonment for 7 years ideally as per the rules. But Due to pendency of cases and continuous delay, now he is in jail for extra 1 year. So who is gonna compensate this extra time for which he is already in jail? So in this sort of situation, when this all situation arises, the family or the representatives of A, whatever the case may be, they can file by virtue of writ of habeas corpus a case in court that this is one extra year that this person has spent in jail. Now I want him to come out, because now it's the mistake of the authorities, it's mistake on part of the authority. Whatever crime he has committed, he had got the punishment for it. Punishment was imprisoned term of 7 years, but because of the authorities problem, he has served 1 extra year in the jail. So now he has to be set free, because now his punishment time is over. So by virtue of this writ habeas corpus, the family or the representatives of A can file a case and set him free. So that is what habeas corpus is generally used for. And if such kind of like 1 year extra or whatever time extra period that person has spent, so generally for this sort of trauma, they are provided with certain amount of compensation that depends upon the discretion of court basically. So having said that, let me return to the point where we were as per this book. So by section 491 of Criminal Procedure Code of 1898, please remember when this book came into existence, 1898, Criminal Procedure Code, section 491, the power to issue writs which was with the charter high courts, that was taken away from them after the enactment of Government of India Act 1935. Power to issue habeas corpus writ was restored. So you see, Government of India Act brought again this writ. Subsequent to enactment of Constitution 1950, everybody well and well knows that High Courts were recognized by Constitution and power to issue writs, orders or directions was conferred on them under Article 226 of Constitution. Now that means as per the Constitution, in today's date, High Courts and Supreme Court both have their own jurisdictions and their own powers, but both have equal powers to issue writs. Both have the power to issue 5 kinds of writs, whatever the case may be. And high courts are conferred with the power to issue writs as per the Article 226 of Indian Constitution, whereas the Supreme Court is granted power to issue writs as per Article 32 of Indian Constitution. Moreover, you can find out. Now, during the British period, Privy Council acted as highest court of appeal. We know in today's era, in India, Supreme Court is the highest court of appeal, but at that time when the Britishers ruled over us, their own court, that is the Privy Council, was considered as the highest court of appeal. Appeals came from colonies and certain other locations over which British exercised jurisdiction. Means जहाँ पर भी ब्रिटेन ने जिस भी कंट्री को एनेक्स किया हुआ था, जहाँ पर उसका कंट्रोल था, उस हर जगह से मैटर्स एज एन अपील प्रिवी काउंसिल में आते थे, क्योंकि हर जगह का हाईएस्ट कोर्ट क्या रहा होगा? प्रिवी काउंसिल. In 1833, a distinct judicial committee of Privy Council was appointed with jurisdiction over colonial, athletical and sundry other matters. The law lords of House of Lords adjudicated cases before the council. The state sued and was sued in the name of British sovereign in her capacity as Empress of India. That means case was filed against the state also, against the government also. And what was written, like if you know, in today's era, there are cases where it is written versus state of MP, state of UP, state of Haryana. So against the whole state government, the cases can be filed in today's date. And it is also sometimes written versus Union of India, UOI. That means against the Union government or the Indian government directly, the cases can be filed. So as we know, crime is always committed against the whole society. it is true that if a crime is committed, there is one person or a group of certain people who are directly affected by it, but then to the whole society indirectly also it is affected due to the crime being committed. So a crime always affect the whole society. So in that case, in such situations, cases may be filed against the government directly. So government can be sued, or in other matters also government can be sued. So that is what it is written over here, that the state सूट मतलब स्टेट दूसरों के खिलाफ केस कर सकता था और कोई और बंदा स्टेट के खिलाफ भी केस कर सकता था. और क्या नाम देते थे? ब्रिटिश सोवरेन का नाम देते थे, और उनका नाम क्या था? एम्प्रेस ऑफ इंडिया, यहाँ की रानी. ठीक है. Privy Council served as a bridge between Indian and English legal systems. क्योंकि यहाँ से सबसे हाईएस्ट कौन था? प्रिवी काउंसिल. और वहाँ पे इंग्लिश जजेस ही इन मैटर्स को देखते थे. क्योंकि याद करो, इंडियंस की अपॉइंटमेंट एज अ जज बंद हो गई थी, तो सारे जजेस इंग्लिश थे. और अगर कोई कोर्ट इंग्लैंड का है तो ऑब्वियसली उसमें तो इंग्लिश जजेस ही बैठाएंगे, इंडियंस या किसी और कंट्री के नहीं बैठाएंगे. तो प्रिवी काउंसिल के जो भी जजेस थे, इंग्लिश जजेस, दैट सर्व्ड एज अ ब्रिज. क्योंकि उसमें एज एन अपील जब आप स्टेट गवर्नमेंट के या ब्रिटिश गवर्नमेंट के अगेंस्ट भी केस फाइल कर सकते हो, तो इट एक्टेड एज अ ब्रिज और टू सॉल्व द मैटर्स बिटवीन द गवर्नमेंट एंड द इंडियन पीपल. After India attained independence, jurisdiction of Privy Council was abolished by Abolition of Privy Council Jurisdiction Act 1949. So by the name itself of the act, you can predict what was in this act to abolish the jurisdiction of Privy Council. After independence, so it was in the year 1949. The Privy Council served as highest court of appeals from India for a period of nearly 200 years, and this is the same time period for which nearly Britishers ruled over us. That's why for nearly approximately 200 years time period, Privy Council was the highest court of law as an appellate jurisdiction that it served from India, and has rendered several landmark decisions which have influenced the evolution of law in India. Yes, it's true, we have taken so many good things or so many administration principles we have took from